Hola.
A alguien no se le escucha bien el sonido. Creo que es a Roberto, tal vez.
Buenas tardes para todos. Bienvenidos a este último panel de nuestra semana de la propiedad intelectual, el interés público y COVID-19. Durante este tiempo, de aquí hasta antecitos de las 3 de la tarde, desarrollaremos la discusión sobre el impacto de los aspectos de propiedad intelectual de los tratados de libre comercio sobre la respuesta a COVID-19. Quiero destacar que este panel lo hemos concebido como un homenaje a nuestro amigo Germán Holguín, quien tuvo un papel preponderante durante las negociaciones del Tratado de Libre Comercio de Colombia y Perú, tanto con los Estados Unidos como la Unión Europea, y fue uno de los mentores que tuvimos muchos de los que estamos trabajando actualmente sobre estos temas de propiedad intelectual y acceso a medicamentos. En el panel de hoy nos acompañarán 5 conferencistas. Contaremos con la presencia de Roberto López, quien es sociólogo y hace parte de la organización Acción Internacional por la Salud de Perú. Ha tenido participación en programas de salud comunitaria, en diversos estudios y evaluaciones de programas de salud y medicamentos, y en actividades de difusión de información sobre medicamentos en relación a su uso racional y acceso. Tiene experiencia en abogacía en relación al acceso universal a medicamentos y a otras tecnologías sanitarias. Tenemos también la compañía de Fabiana Jorge, quien es la fundadora y presidenta de MFJ International, una firma global de consultoría especializada en negocios internacionales y comercio exterior. Fue negociadora comercial y tiene más de 25 años de experiencia ayudando a empresas a abrir mercados internacionales y expandirse globalmente. Y también ha trabajado durante 25 años abogando por evitar los efectos de la propiedad intelectual sobre el acceso a medicamentos asequibles. Y también pues tuvo una participación activa en varias negociaciones comerciales de diferentes tratados como el ALCA, el TLC entre Chile y Estados Unidos y actualmente en la Asociación Transpacífica. Contamos también con Nirmalia, quien es el oficial senior del programa de salud, propiedad intelectual y biodiversidad del Centro del Sur. Tiene 15 años de experiencia trabajando con agencias gubernamentales en contextos nacionales y multilaterales sobre temas relacionados con propiedad intelectual
matters in topics having
intelectual, comercio y acceso.
and access to medication. Before working for the Centro Sur in 2008, he was as an associated member for trade and development, a group of reflection on these matters in New Delhi, India. We also have the participation of Joan Rovira, an economist and professor at the University of Barcelona, ample experience in the design and evaluation of the impact of aspects of intellectual property linked to the free trade agreements as far as access to medication. And finally, we also have the participation of Miguel Cortés, who is currently the vice president of the National School of Pharmaceutical Chemicals in Colombia, masters in business administration, and advisor at the Office of Project at the United Nations, and he studied impact of intellectual property on access to medication in several countries in Latin America. So, with this introduction, I extend my greetings to all panelists, and let me remind you that you have 15 minutes for your interventions. At the end, we will have a round for questions and answers and conclusions. So, I give the floor to Roberto for us to begin this session. Good afternoon, everyone. It's a pleasure to be here with so many friends in order to deal with these topics that seem so complicated and which have taken most of our efforts in our lives. But for above, or first of all, before anything, I would like to mention the person who inspired many of our struggles and the past and the current ones. And he's Germán Holguín Zamorano, the director. He was the director of the health mission. I think it's not exaggerated to say that he has been a tireless fighter for health and access to medication. He started, first of all, with a bank of medication to serve the people in most need in Colombia. He also he was also one of the activists who became like a locomotor in the structuring of the global network, which so far has been struggling for access to medication. However, it's important to say also that he was the leader who took us to the Inter-American Commission of Human Rights, where the proposal to consider the lack of access to medication, to consider it as a crime against humanity. I particularly have to say that many struggles, minor and major struggles, united us. And one of them I can remember was the work at the Chamber of Representatives and Senators of the United States when the free trade agreement between the United States, Peru, and Colombia had practically terminated.
Foi um trabalho muito
So it was a very enriching work trying to convince, especially Democrats, that this free trade agreement that had terminated was not beneficial to economic partners like Peru and Colombia. So, as a result of this, and in order not to extend myself anymore, a protocol of amendment was approved in this FTA, and it's got some important aspects. But unfortunately, we need to consider that the FTA between Peru and the United States, just like others, is an extra. It's beyond what ACPIC requires. I want to mention two things about this FTA. First of all, exclusive nature and deadlines for evidence data. There, we don't talk about exclusive nature or terms for the protection of non-disclosed information. The other one is they force Peru, in this case, to patent vegetables, saying and reading in the text that reasonable efforts should be made to get to this patent. That's a very broad field. And the other part, which has a lot to do with intellectual property and which restricts the activities of the states, is the concept of direct expropriation, through which a company can sue a state or a country like Peru or Colombia because they argue that their investments have been affected because, for example, the country and the state gave or issued a law which whereby, for example, they prohibit tobacco following the standards of the World Health Organization, and they can sue the state. And this is what indeed happened between Philip Morris and Uruguay. The issue is that after so many years, 25 years of this entire process, it would be interesting to remember what the conditions were uh, on which the organizations of the civil society were present in this process. It wasn't easy. First of all, it's a negotiation between different parties, countries which have a series of asymmetries, uh, different technological and scientific developments. If you compare the United States with Peru or Colombia, the mobility rate, the consumption of goods and services, there are many problems which have not still been solved at a level of the population. However, it is considered as a negotiation. The second aspect is that the powerful country has a right to a veto. And during the first meeting of the FTA, Peru, Colombia, and the United States, the head of the North American negotiators told us that agricultural subsidies would not be discussed during these negotiations. That is, they have a right to a veto, and no one within our table of negotiators said, okay, so we won't want to discuss here copyrights. We will leave that to the World Organization of Trade or Trade Organization, the multilateral entity. So the negotiation becomes an imposition of topics and a series of measures, and of course, lack of transparency. The participation of the organizations of civil society in what we call the side rooms was very ritual. I mean, the information that was being distributed was ambiguous, outdated, and whatever was convenient for the negotiators. Here in Peru, they also demanded from the members of the civil society, in order to participate in these sessions, a letter of confidentiality. And of course, we refused to that here. And not only that, in a negotiation, it's even more difficult when one of the states, uh, like for example, Toledo in 2004 said, this FTA is going to be signed yes or yes, no matter what. Can you imagine the strength that a negotiator will have sitting down when you have the president of the other country? This has to be signed no matter what. Or when a series of questions are suggested after the FTA negotiation is finished. Alan Garcia, the presidential candidate in 2006, said, let's review the FTA line by line and word by word. Of course, he didn't do anything. He signed the FTA deceiving the population. And Garcia, additionally, when the TPP started to be discussed, or the FTA with the European Union, he threatened to remove Peru from the Andean Community of Nations if this meant not to make progress with the FTA with the European Union. That way, it is very difficult to have an authentic negotiation. Besides, the national sectors were present during these negotiations. Somehow they were linked to the dynamics of the countries of the north. They were taking care of their businesses, and so far as intellectual property, they were not interested in public health. Besides, the commercial agreements are also seen by these economic elite of our countries as an instrument to armor the status quo, to make it irreversible somehow. And of no less importance, it is worth mentioning that there is a process of cooptation of the negotiators by the Office of Trade in the United States. In reality, our negotiators have practically been spokespersons of the Office of Negotiators in the United States. Claudia, let me know when there are 2 minutes left. So the issue is, as you all know, at peak is a multilateral effort which benefits transnational companies. This was a creation of transnational companies, and all FTAs are ADPIC plus, and it's all about, completing what was left open or incomplete in the ADPIC. And this is what we have today. The countries who have signed FTAs have ADPIC plus. And it is worth remembering these words in a document of the Vatican, which was proposed during some meeting of the World Trade Organization during 2013 in Bali, and which I think summarizes two very important aspects of these trade agreements. First of all, they strengthen monopolies on medication, reducing access and accessibility. And second, they provide excessive legal rights to foreign investors. This is what happens, and that's why I was mentioning before that the concept of indirect expropriation, which allows companies to prosecute the states and not state-owned companies, right? So it was the Vatican who imposed, or I mean, who wrote these again in the agenda of discussion when trying to negotiate the TPP agreement. And here I want to start concluding by giving you a few ideas regarding the challenges imposed upon by the pandemic and public interests. We all know we need treatment that doesn't exist yet for COVID-19. We also need vaccines to prevent COVID-19. We don't have them yet. We've already seen some movements of transnational companies like Gilead in the case of Remdesivir, which in addition to not work for COVID-19, it has strengthened its patents, providing voluntary licenses to some countries, as has always been the case. The vaccine as world public good is a concept that is kind of disappearing or dropping importance, or because we haven't seen a sufficiently aggressive and appropriate mechanism for it to become a vaccine that can be accessed massively at, complying with the epidemiological criteria of each country and the world in general. So the issue was there were reactions from big pharma and this request to decline intellectual property, declaring that this was something that made no sense and that it was dangerous for research and development of new medication, in this case, the vaccine. Besides, the vaccine as world public good is now subject to big queues by rich and not so rich countries to obtain the first positions in production, because they haven't assured yet that this will reach the entire population. It is worth highlighting, and we've seen in some of the sessions of this Congress the brave position of South Africa and India in the World Health Organization, proposing a solution to suspend intellectual property or intellectual property rights, not only for patents, but also for other subjects that are protected by these rights. It's a matter that I think summons all of us to continue struggling for access to medication. And I think health goes beyond the pandemic. The right to health is not only present during a pandemic or referring to COVID. In cancer, we have around 8 million people who die every year around the world, and many of them without any treatment, many of them needing treatment. I don't want to disregard the fact that, yes, we also need prevention, but We need treatment to be given to many men and women around the world, and the treatments are excessively expensive because they're precisely handled by monopolies. The same happens with hepatitis C, with death and damage that can lead to cirrhosis or damage to the liver. 70 million people around the world die of this, and the list is long of the millions of people, men and women, who die every year, and the right to health and to life assists them. This is not just only in pandemics. And what is behind at peaks and free trade agreements? What we have is a model of production of medication in the hands of large companies, which link price with the cost of research and development. Is the question we need to formulate ourselves is this untouchable? We know that in the context of the World Health Organization, almost up to 10 years ago, I mean, to test a new modality, a new model for funding in research and development of new medication, has been left aside. It has been weakened, but I think the program for medication of disregarded illnesses, which was born as Doctors Without Borders, shows that it is possible to have some other models of for research and development of other issues without linking the cost. And on the opposite, it might reduce the cost for research and development. So this should be part of the agenda during pandemic and after the pandemic. Roberto, I'm sorry, you have 2 minutes left. Okay, I'm about to finish. The last thing I wanted to refer to, how is it that multilateralism has been co-opted by the large multinational companies? We have multilateralism by transnationals, and this is one of the things that we have to work on. We need to recover multilateral organizations. We have to become more cosmopolitan citizens and really a world global citizenship which can recover, as I repeated, multilateral organizations and place them at the service of humanity. Thank you very much. Thank you very much, Roberto, for your intervention. And to briefly summarize, I first want to thank you for reminding us all of the role played by Mr. Olguin during the negotiations and the process that led to the lawsuit before the Inter-American Court of Human Rights. This was very important. I mean, with his leadership, this was possible, and we need to continue working on this matter. You also mentioned the impact brought by the implementation of what was negotiated with the FDA between the United States and our countries, Colombia and Peru, and the difficulties they had to experience to have participation by the civil society and lack of transparency. And finally, you presented the challenges that we're facing right now and which brought us together with this pandemic. Two notes. I want to remind you that we have simultaneous translation into Spanish, English, and Portuguese. And in case you want to ask questions, you can do so through the option of questions and answers in the Q&A, or you can raise your hands and the microphone can be open for you to make your intervention or ask your question. So let's continue now with Maria Fabiana Jorge. I am going to share the screen for her presentation. Give me 1 second, please. Okay, Fabiana, the only thing I request from you is whenever you need a change, let me know every time you want to change the view graph. So first of all, I want to thank everyone for including me today and greeting so many friends that have been sharing this struggle to have access to medicine or medication, which wouldn't be possible without each one of your contributions. So thank you all. It's a pleasure really to be here with you. Voy a pasar a hablar en
The presentation is in English, but if you guys want me to switch to Spanish, I can do that as well. So La próxima, por favor, Claudia. So we don't have a lot of time, so I will go very briefly, but I want to mention one thing. This is not just about the actual trade negotiations. This effort is a very complex system where the trade negotiation is only the first stage of a multiple effort to really raise the levels of intellectual property and increase the monopoly. So the trade negotiation, when we finish the trade negotiation, it's only the first part finished, and then start a fight over implementation, which I'm going to address with specific examples later. Then the special 301 for whatever some interest groups didn't get in the first two stages. They try to get it through the special 301 and now through the Trade Facilitation and Trade Enforcement Act. There's no time to speak about that, especially the last one, probably many people do know now, but it's a real problem.
Es un problema.
And also, while in the past, mostly these higher levels of intellectual property or TRIPS Plus was coming from US negotiations, now some interest groups have been able to incorporate some of these provisions in EU negotiations as well. And we need to really focus on these before it's too late. Next one, please. So I was asked also to talk about a little bit of both substantively, but also how some actions really make a difference in these negotiations. It was mentioned about Holguín and all the efforts that he has done, and I'm going to offer another piece that also was critical for the new trade policy. So during the negotiation, we were the technical advice, the negotiation with Peru and Colombia. We were the technical advisors for the IP negotiation, for the IP group, for the government of Colombia. For the first time, the government of Colombia, the first time ever that a government presented an alternative text to the US. Normally, countries were negotiating only on the basis of the US text. So they were doing a pretty good job, but just like Roberto said, President Toledo decided that he was going to sign the agreement before he left office. It was in December, I don't remember which year now. And he did sign the agreement, and it was a really bad text. And that was a really bad moment in the negotiation, because then the USTR told the government of Colombia, okay, Peru already accepted, is this or nothing? And it was so hard because the negotiators were doing such a good job, but they were put in a really bad position, and that was at the end decided by the highest political level. And in fact, the president of Colombia went to the IP table to ask for clarifications, just to make sure that it will not affect access to medicines. And of course, they told him whatever he wanted to hear, and Colombia accepted the text. And it was a really low moment for many of us that have been working really hard to make a difference. And it was like, please tell us you got something, that you didn't give up all these for nothing. It was really a bad moment. But move on, and we never give up, right? We always keep working out. We always keep fighting, because the fight is way too big to give it up. So at some point, this agreement had not been ratified yet. At some point, one of the top level officials came to Washington and wanted to get input from us about how to pass the agreement in Congress. Without that, it was not in effect. So we gave him advice. We were not working for the government anymore. And then we said, if the Democrats win the election in the House of Representatives in 2006, if the Democrats win the election, will you ask for a renegotiation of the terms? And this person say, no, we will never ask for a renegotiation. But if they renegotiate, we will sign. So we will have preferred, yes, we will ask for a renegotiation, but we have to act based on reality, right? And that was the reality. When the Democrats won the election that November, then my colleague Dolores Callen and I went and met with the Ways and Means Committee, two key people there. And they knew that there was a problem with the agreement. The agreement was signed and finished. They knew it was a problem on access to medicines, but they didn't know the technical aspects. They couldn't put the finger on this provision or that provision or why. They just knew the concept in general that it was a problem. And they were planning to do a hearing. And hearings are good because they raise the visibility of problems, but hearings don't fix anything, right? You can do the meeting, raise the issue, but nothing changes. So when we told him, if you guys
Entonces le dijimos que si ustedes nos permiten, con base en algo que nunca han pensado, ahora ya sabían que aquí había como una nueva avenida, entonces se encontraron pues con estas personas, trabajamos con ellos durante 4 meses para que aprendieran sobre todos estos problemas y trabajamos muy duro, ayudándoles a entender cuáles eran las implicaciones para los diferentes idiomas y en cierto punto estas personas le dijo a los Estados Unidos, le dije, quieren aprobar esto en el Congreso y lo quieren ratificar, tienen que renegociar con nosotros. Entonces, la renegociación se dio entre el comité de los demócratas y del USDR. Entonces, se dio la nueva política de comercio de los Estados Unidos, se logró un acuerdo. No tengo tiempo para explicar todo esto, pero hay una...
So anyways, that just to give a sense on this.
Simplemente para no darle sentido a esto, sino...
TPP and the USMCA, which I want to mention some. Next one, please. Next one. Okay, so Roberto went over some of the issues. Next one, please. Of this issue. Next.
Problemas de
so the issue
vio Roberto, y el problema aquí es cuando la nueva política será un punto de quiebre o algún momento, digamos, en la historia, en el pasado. Entonces vamos a ver la siguiente. Roberto mencionó entonces, algunos de los problemas que habíamos visto en el acuerdo y otros que pudimos eliminar.
Briefly, so we were able to eliminate the patent term
Pudimos
extension.
eliminar la patente de extensiones hacia los farmacéuticos.
May instead of shall, so it was
Los fármacos se logró esto.
but it was no mandatory.
Los países lo permitían, aunque no era obligatorio. Entonces cambiamos el número de elementos
I always say this is
exclusivas de datos y yo veo
every word has
prácticamente habían trampas, todas las palabras tenían trampas y nosotros pudimos cambiar muchas cosas. Este alcance
words like undisclosed or
para
changing.
incluir palabras como no revelado y el cambio de
The periods were
los periodos nos permitían hacer tiempos consecutivos, no sé, esto se podía cambiar a concurrente, por ejemplo, hubo una cantidad de elementos diferentes que había que cambiar con exclusividad. La siguiente, no voy a leer todo esto porque no tenemos suficiente tiempo. La siguiente, por favor. Y luego el enlace fue muy importante porque nosotros creo que esta fue una de las peores estipulaciones y pudimos eliminarla. Esa obligatoria. Y dijimos, bueno, no solamente podemos eliminar. Entonces, la forma fue que nosotros exigimos que los tener un sistema legal para de juicios para poder retar el impeachment de aquí tenemos, esto fue lo que se hizo. Esto se eliminó y solamente hay referencia a que tenía transparencia para la aprobación del mercado y tener un buen sistema, un sistema legal que funcione. Y el siguiente.
So we talk about the problem of implementation, right? So we were so happy this was changed. First time ever, a trade agreement is finished and reopened, and the countries did sign, just like this official said. And then someone give us a text that is
Alquios nos dio un texto de que la implementación ya se estaba trabajando en la implementación y después de haber iniciado el acuerdo. Y entonces yo pues quería moverme porque estaban implementando era lo antiguo antes de que.
Oh my gosh, we were so hard and now they are not using it. So the chairman of the health committee in the Peruvian government had invited us in the past to go. We called him and say, you wanted to invite us, this is the time.
Lo llamamos y le dijimos, bueno, usted nos puede llamar para poder negociar todo esto. El gobierno en ese momento pues tenía el poder, entonces el ministro de salud estaba hablando con el comité y nosotros simplemente nos permitieron hablar después de él. O sea, le prestaron atención más al ministro.
And we say at that time that we were concerned that we heard that the government was working on the implementation of the old text, not the new text. That afternoon was a little unpleasant. We had a meeting with the Ministry of Economics. I was in charge of the negotiation. They canceled our meeting. But we did meet with many other people in the government, and we told them about what was going on, and they didn't know. Not even the MP knew. So we explained what was going on, and they called the people in the Ministry of Economics and figured out whether it was true or not. It was true. So created a big problem. And then 2 weeks later, the Peruvian embassy called us and say, okay, the Ministry of Economics went publicly, it was a woman, it was publicly and say they will implement the new agreement. So what I want to say is we all together, working together, like we have been doing.
Lo que quiero decir es que trabajando juntos tal como hemos estado haciendo.
Exacto. But basically we cannot
básicamente,
sorry, the translation is coming through to me.
Yeah, through the audio.
Okay, so if we can go to the next one. So the issue is that even if the negotiation is fixed, then we have to be careful with the negotiation, with the implementation, and then the other areas. Very quickly on the CPTPP, there were two significant efforts, one during the actual negotiation and one after the US withdrew with President Trump. So during the negotiation, next one, please. I don't have the time to go over every provision, but just to have a sense, the first column is the original US proposal and how we end up with a TPP. So there were elimination of the restrictions of patentability from the TRIPS, the part of plants and animals.
De parte de plantas y animales no estaba incluida y había un idioma específico, un idioma de la India en donde India no estaba en el acuerdo. Lo estaban incluyendo para asegurarse que no estaban siguiendo lo que era el lenguaje de la India.
No, está otra vez la traducción.
Yeah.
Disculpa un segundo, María Eugenia, por favor, ¿puedes cambiar el canal a español? No estás traduciendo en español en el canal en inglés. Gracias, perdón por la interrupción.
Perdón, Diego, pero yo estaba en español y no me cogía tampoco, me cerraba el micrófono. El micrófono.
Si quieren que hable en español, hablo en español, es lo mismo para mí.
No, ya estamos resolviendo el problema del intérprete. Te quedan 2 minutos, Fabiana.
Bueno,
perdón.
Espero que me den los minutos extras de esto. Bueno,
Claro.
No tengo tiempo para cubrir todo, pero había problemas de patentable subject matter, the new uses that was incorporated. More, please. Another slide.
La siguiente diapositiva.
With the data provision that we were able to fix during the negotiation. Next one, please. Clearly, biologics was a big issue. There was the 12 years that the USTR wanted to get, and we end up with. And well,
Para 5 o 8 años, si no los
others like Bolar and other things. So there were many issues that we were able to fix during the negotiation. But next one, please. But there was still many problems still in the language. That's a bio paper about the 12 years, and we wrote and published an article on why that was bad, the biologics and trade agreements.
sobre los
Use that to help the negotiators to understand the issues. Next, please. What happened after the US withdrew, we thought we could still make a difference. The US Generic Association did not think that they had to focus because the US was not there anymore, but we thought it was important because we could still make a difference. And we worked with the negotiators. They were very scared about making any changes because without the US, they were worried that everything will disappear. And they were even more worried that that will disappear if they start making changes. But at the end, working with all the different negotiators one at a time, we were able to, the negotiators agreed to suspend a number of provisions that were still concerning. That was the new uses, the exclusivity for small molecules altogether, the exclusivity for biologics altogether, and the patent term extensions. Next, please. And with the USMCA, I'm just going to say a couple words. Again, we finished with a bad agreement. I believe that some players didn't play.
Y algunos de los
que algumas das coisas
have to oppose some of these provisions. Again, we end up with a bad agreement. Next one, please. Again, it was almost like a replay of the new trade policy. The Democrats won the House in 16. At the beginning, they were only focusing on labor and environment, but we were able to bring back the issue of access to medicines. And the Ways and Means Committee, again, say you have to renegotiate this agreement for labor, environment, and access to medicines. There were only 9 offices in the US Congress that were negotiating with the USTR. There were about 2 or 3 that were doing access to medicines. We were working really closely with them in terms of providing text and alternatives and all that, and eventually was eliminated the additional patentable subject matter, the new uses and all that was eliminated completely. The biologics article was eliminated, the additional 3 years for small molecules. And there was also included, next one please, the additional provisions. Okay, so now the problem is about implementation. Unfortunately, Mexico, and I have to say the things as they are, the government of Mexico did not defend their people during the negotiation, did nothing to negotiate. And unfortunately, during the implementation, they also did not even use the changes, all the changes. So unfortunately, 4 days before the vote in the Congress, in the Senate, we find out about a language that was including new uses. And we worked super hard. US Congress sent a letter saying that was not what they were hoping and so forth. And unfortunately, in the new law in Mexico, they have new uses, even though they are not required. And having that in the middle of a pandemic is outrageous. I don't understand, if the government doesn't defend their own people, who is going to defend them? So next one. So whatever you guys can do to work with Mexico, and certainly we will continue trying to make a difference, but this is outrageous. And also they have limitations on compulsory licensing that they could have fixed in the middle of a pandemic. I will say that is an important thing, but it seems that for them it's not important and they didn't fix it. And of course, they didn't take any of the possibilities of the advantage on restrictions on the extensions of patents or anything like that. So moving forward, I think that part will depend on what happened with the election and which kind of government we have here. But I want to raise again the issue of the EU trade agreements. We have been involved with the CETA negotiation and with the Mercosur-EU negotiation. And it's a problem because some interest groups are getting into the EU and pushing for language that is clearly TRIPS plus. And I would say we need to follow the money, and that is biologic and clinic and chronic diseases. And it's getting a lot more complex for many different issues. I don't have more time for that. Last thing I'm going to say, next one, please. Following with what Roberto was mentioning, so before COVID-19, when we were talking about compulsory licensing, the originator companies have always were saying, oh, it's only reserved for health emergencies, which is not true. We know that is not true. It's very clear in the TRIPS agreement, but that was always their speech. Now we have a health emergency and they say, oh no, it's about quality. Other companies cannot do the quality. So they cannot argue that it's not a health emergency, but now they're using quality. So Roberto mentioned about remdesivir, and there's two issues. Clearly, one is the patents, and also the other is they were applying for orphan exclusivity, so 7 years of exclusivity on top of all the patents. As you all know, the orphan exclusivity is for a very small amount of patients that need that medication. Clearly, under no circumstance, the middle of the pandemic, you could argue that it's not enough patients that could need it. And there has been a letter from 34 attorney generals to the Secretary of HHS, ASAR, and others, saying we need to use the Bayh-Dole Act, which basically allows for compulsory licensing in cases that the prices are too high or in cases that they cannot provide enough supply. So far, the HHS secretary has rejected that. It says that it only will do it if the government owns all the patents, which is not the case. And last thing, Claudia, and I finish. Representative Rakowski and Senator Warren have a bill to introduce non-voluntary licenses with compensation with royalties for the cases of vaccines or so. And there are some companies like Moderna that just this week say that they will not enforce their intellectual property rights, their patents over the vaccine that they are producing for COVID-19. So with that, thank you very much. And thank you all for all the work you guys are doing. And it's so great to work together.
Gracias, María Fabiana. Muy interesante tu.
Thank you, Maria Fabiana. Your presentation was very interesting, but this brings to our minds the process of the negotiation seen from the other side, from the civil society, from the counterpart. This is an important antecedent, and having made a renegotiation is something unprecedented, and having achieved or having been able to change the language details that shows that in some cases the devil is in the details. So this is exactly how it is written and what implications are going to be in the implementation. So you were talking about the problems of the implementation, although there were good progress on the implementation of the treaty. The local government seemed to be more in agreement with the non-negotiated treaty than having things that had been left outside. And according to you, you never know who the governments are defending in these cases. And now to finish, you showed us the challenges that are occurring in the COVID-19 pandemics. And this proves that this model of a intellectual property that was only a problem for the middle income and low income countries is now affecting the high income countries, and they have a problem for the implementation of the protection measures that they have included in their regulations. Thank you very much. Now we will continue now with Nirmalya from the South Sapper, who is going to talk about the impact of the restrictive measures which have already been mentioned in the free trade agreement about the access to drugs. Dear Malian, you can now.
Nirmalia,
hello, yeah, can you hear me?
Hi, yes. Can you turn on your video, please?
Right.
Well, as you prefer. Okay, right. We can see you now.
Good afternoon, and from here in Geneva, and good evening to colleagues who are closer by in my time zone. I will speak about TRIPS plus provisions and FTAs in the context of essentially COVID-19. Maria had just now spoken about provisions in the context of the FTA negotiations in which she was involved. And there are interesting flexibilities and interesting safeguards that were ensured. But there are a number of other free trade agreements with other countries, as you are well aware, where some of these safeguards do not exist. And essentially what I would like to try to point out is how these TRIPS plus provisions impact the response to COVID-19, in the sense that there is need, as we know, for timely, rapid deployment, rapid availability of the health technologies that are required for intervening.
Días de la salud.
The problem here is one of scale, one of supply side constraints, because the global demand is unprecedented, and there are not enough manufacturing capacities to get put together in the world at the moment to meet this demand at the speed at which it is required. So what this means is that the technology has to be shared, the technology has to be transferred, not only for new research and development that is ongoing, but for any existing technology which could be deployed for the same. And in this regard, intellectual property rights, particularly TRIPS plus provisions in free trade agreements, can become a significant impediment. Now, what are the COVID-19 related health technologies that or how could COVID-19 related health technologies be impacted by IP rights in terms of being protected by them? These include, for example, drugs, existing drugs. We just heard of remdesivir. We are hearing a lot of news on dexamethasone. These are both existing drugs which are being considered to be repurposed for treatment of COVID-19. We've also heard in the past about trastuzumab as another candidate which could be repurposed for certain kinds of cases of certain severe cases of COVID-19. Then there could be new drugs which perhaps would be developed. There is the Solidarity trial going on. There is a hectic research and development activity going on, though there is no particular new candidate drug that is in the pipeline as promising. This could come up in future, and the world would hope that this would happen sooner rather than later. Once this happens, whether IP rights can be taken on them and what is the scope of those IP rights would become a particularly relevant consideration. In the case of vaccines, already we have seen in the United States patent disputes involving Moderna and Inovio, which have been litigated in the courts. There is significant concern as to whether intellectual property rights will be taken on these vaccines. We've just seen in the previous presentation about the pledge made by Moderna that they will not impose their intellectual property rights, but this is just a voluntary commitment. Legally, there is nothing stopping them from reneging on that pledge if they wish to. So, so these options are always on the table, and IP is therefore a real issue in that context. There could be certain enzymes necessary for production of the vaccines, which could end up being protected by patents. Then in the context of ventilators, also we have seen the use of 3D printing technologies for manufacturing ventilators has led to potential design infringement issues coming up in the context of Italy in the early days of the pandemic. Famously, the head of 3M had also, or the governor of Kentucky in the United States had also mentioned that in the context of N95 masks, the existence of patents was proving to be an impediment towards scaling up the volume of production that was required at the time at the beginning of the pandemic. There is also the case with regard to diagnostics, where in the Netherlands, initially rapid antigen tests or RC-PCR tests, I'm not sure which one, but which was supplied by Roche to Dutch companies, but Roche refused to share with the Dutch companies the buffer solution, the formula for manufacturing the buffer solution, which was an essential component to be, or an essential ingredient which had to be used in conducting the tests. And it was only when the Dutch authorities and later on the European authorities launched or threatened to launch an investigation into competition abuse that Roche reneged and shared the formula for manufacturing the buffer solution for the diagnostic test kits with the Dutch companies. So this also suggests that trade secrets can become a significant issue in the context of COVID-19. So a whole host of IP rights beyond patents will come into play and can become very, very relevant in the context of COVID-19. And in that context, if the FTAs end up providing extensive protection to those forms of IP rights as well, and we know, for example, in the CPTPP, trade secrets has been a major area of interest for the United States, though they are not a party now, but in the negotiations, this was a major issue of interest. And I would be better informed perhaps by one of your colleagues about whether that is still in the text or not, because I haven't checked of late. But that was certainly an issue during the negotiations. Now, what are the general kinds of TRIPS Plus provisions that we see across the spectrum of FTAs with variances and safeguards in more of the recent ones that we have seen in Latin America? These include accession to the WIPO Patent Cooperation Treaty and the Patent Law Treaty, for example. Now, why is that significant in the context of COVID-19? As new technologies are likely to be patented, this is the assumption in the context of COVID-19, if there is a rush for taking IP rights on this could be facilitated by the Patent Cooperation Treaty, by filing an international patent application at the same time in a number of countries. This becomes easier to do. So there could be a possible increase through this route in internationally filed patent applications on health technologies for COVID-19. And the other issue to note is that PCT has an effective blackout on publication of information of what patent applications have been filed for an 18-month period from the date of its original filing. That means that for 1.5 years from the date of filing, the world would not know what kind of patent applications have been filed. So for example, today or maybe a couple of months back, if somebody had filed a patent application on a technology which is necessary for manufacturing a vaccine down the line, or in relation to a diagnostic kit, etc., we won't know about that until 18 months when the PCT application is finally published. And this is in the rules of the PCT system, so you won't have an earlier publication unless the applicant voluntarily decides to disclose that. So these become significant systemic issues in a context where you need rapid information of what is there in the pipeline, what kind of patent applications have been filed, so that you know whether as a third party manufacturing technology in a similar field, you would potentially enter into any patent infringement situation or not, and whether that would impact your business, your viability prospects. Application of relaxed patentability standards. We have already heard in the CPTPP, there was this attempt to sort of discourage other countries from adopting approaches that India, for example, adopted in its legislation. But then it is a fact of life that there are a number of free trade agreements, TRIPS plus provisions that require the grant of the use of relaxed patentability standards do exist. These include second use claims for repurposed drugs, dosage claims, etc. And all these could come into play as we find new users of existing drugs for COVID-19 pandemic. For example, an open question would be, I mean, I hope that's not the case, but for example, if somebody hypothetically files a second use claim for dexamethasone in the context of COVID, would that be allowed in a patent office? And if a patent office in a country is obliged to do so by virtue of a TRIPS plus provision under an FTA that it has signed up to, then that would become a serious problem. Of course, there are restrictions on patent opposition, restrictions on early working exemptions, particularly quantitative restrictions on volumes that can be manufactured. So some FTAs only allow the country to manufacture using the BOLAR provision only a certain number of batches of a medicine that would be required in order to get the regulatory approval, but not beyond that, which is not the case in TRIPS agreement, because under TRIPS, the BOLAR provision does not provide any quantitative restrictions on the number or the volumes that you can produce. Data exclusivity, again, is a very, very significant restriction that has been imposed on a number of countries through TRIPS plus provisions. And as we go into clinical trials for vaccines and for medicines in the future, these would become major hurdles potentially in the area of in the interest of ensuring rapid and timely access and manufacturing of the local manufacturing of these technologies. Some FTAs include specific restrictions on marketing approval for drugs by using undisclosed test or other data, in addition to a data exclusivity provision. There are also limitations that are imposed in some FTAs on parallel importation by restricting the application of the doctrine of exhaustion to a national market. So essentially, the well from which you could draw in terms of exertion of IP rights would be limited to a national market. And therefore, if the patent holder has not exhausted his right, for example, in that country where the national doctrine applies, then that country cannot undertake a parallel importation of the drug from a third country, which other countries which are not party to that FTA perhaps could do, because under the TRIPS agreement, you're allowed to apply a universal concept of scope of exertion of rights to the global market. There are also issues with patent term extension, which are included in a number of FTAs. And in some contexts, they are actually much more sort of stringent than the patent term extension standard that even applies in the United States. For example, in the United States, the requirement is that the drug regulator would inform the patent holder whether when a marketing approval is being sought for a medicine on which a patent has been granted. But that is the only obligation that the drug regulator has, just to inform the patent holder. And if the patent holder wants to challenge it in a court of law, he can go to a court of law, but the drug regulator has no other business with that. But in some of the FTAs that the United States has negotiated, the requirements are actually more stringent. The regulator does not only have to inform the patent holder, the regulator also has to act ex officio on behalf of the patent holder in a way to deny the registration of the drug. So in that sense, these are excessive even by US standards. Of course, there are investment chapters. Sorry.
You have 2 minutes left.
Yeah, I'll wind up soon. So there are investment chapters in FTAs or bilateral investment treaty provisions also, which can impact this. So what kind of solutions can we explore? in regard to the challenges in the context of COVID-19. Now, one of the issues to look at in a number of FTAs, there are provisions on security exceptions. There could be variances though, so one has to do that mapping properly. But in, for example, I saw that in some of the US FTAs, there is this provision on security exception. They allow parties to use security exception similar to Article 73 of the TRIPS agreement. So in situations of war or other emergency in international relations, a country, as it considers the situation is to be an emergency, can take any measure that it considers appropriate. And this being a subjective consideration is not going to be questioned by a dispute panel, as held, for example, by the GATT panel in United States trade measures affecting Nicaragua in the past. However, a potential problem remains here that a measure that is taken as a security exception may still be challenged under a bilateral investment agreement or through an investor-state dispute settlement. The other issue to look at, and this is my last slide, is that there could be national laws, and we've just heard in Maria's presentation of flexibilities that have been introduced or that have been retained in the FTAs, in some of the FTAs with the United States. So these flexibilities could be utilized in a way to ensure that the scope of public interest is safeguarded to the best extent possible. There is reference to public interest objectives enshrined in Article 7 and 8 of the TRIPS agreement in some of the FTAs as well. These may be resorted to in some limited cases where the FTA provisions are ambiguous. There are also side letters in some of the FTAs which effectively say that nothing in the FTAs will be prejudicial to public health. However, there is also the possibility that it could be counter-argued that this may create a presumption of compatibility of the FTA provisions, TRIPS plus provisions, with public health needs, and this needs to be countered. This kind of an argument would have to be countered. As you are well aware, perhaps, that the United States has the certification system with parties to the FTAs, wherein you would have to, from day one, sort of become fully compliant in their view with the FTA provisions, which is kind of a unilateral determination. The South Center has produced by Professor Carlos Correa a publication in this regard, which explores what are the flexibilities in the context of free trade agreements that countries could use. And we have shared here the link for your reference. I will stop here. And thank you for your time. And if you have any questions later on, I'd be happy to take them. Thank you.
Bueno, muchas gracias, Nirmalia, por tu intervención. Brevemente.
Thank you very much, Nirmalia, for your intervention. I think in your presentation, you briefly showed us what the things are that might go wrong within the framework that we have currently as to how patents can be reinforced, how the duration or the term or extension of the protection can take place in the context we have. The risks are, and I think you also showed us a good panorama of the alternatives or solutions in order to prevent the effect or avoid the effect of these intellectual property protection currently on medication within the framework of the pandemic of COVID-19. Now we give the floor to Miguel Cortés, who will talk about, in the development of impact studies of the aspects having to do with the protection of intellectual property in FTAs regarding access to medication. So Miguel, you have the floor. Can you hear me and can you see the screen? Yes. Okay, great. So thank you very much. It's a pleasure to be part of this panel on this opportunity. I will share with you what the story has been behind this model of impact measured, having to do what the impact is on price, access and expenses on medication. This graph shows the order, the logical order of aspects, maybe from the standpoint of a scientist. We have some health requirements or needs. We do scientific research to define them. We develop technologies. We look for mechanisms allowing us to develop such technologies. One of them might be intellectual property. And it is a mechanism which, in theory, allows us to develop these two technologies and recover or have a return on the investment required for these developments. However, we frequently know it works the opposite way. We normally look for the option that allows me to recover investment quicker, and that's what hinders our development of technologies and solving our problems. I wanted to show this more general panorama to say, okay, let's focus on intellectual property more as an element which allow us to make or develop more technologies, and we've heard this in prior presentations, and we would have two aspects to evaluate here. The first thing is, what do we obtain via intellectual property? What are we protecting? And number two, how much does it cost? If the cost, I mean, is in balance with what we're going to obtain, then we proceed to do so. The story begins, as Roberto was mentioning in his first presentation in 2004. It was created with the intention of becoming a tool which would allow the negotiators of free trade agreements in the countries of Latin America and the Caribbean negotiate with the United States. It was created at the request of the Colombian government and World Health Organization to create a model that could become a tool for negotiators and a simple way to evaluate impact. Currently, we're at that point, we started with iPharma, Misión Salud, and Acción Internacional para la Salud. We started promoting the development and of studies in Asia and ELC between 2004 and 2011. These were prepared and also with the sponsorship of the World Health Organization, Pan American organization, health organization, and the International Center for Trade and Sustainable Development. Up to 2011, we developed this kind of studies in several countries. And there we made a pause until approximately 2017, where the Shuttleworth Foundation promoted a study in Brazil, invites us to continue with the development of this model, mainly to carry out work in Brazil, South Africa, and India. Models of impact. As I told you before, the purpose is for it to become a simple tool. It's not a volumetric model in the strict sense of the word. It's rather a mathematical model with a very simple basis, and we developed two models. The first one is a model which evaluates in an aggregated manner the impact of intellectual property rights. We take into account the size of the market, the percentage of market in exclusiveness by DPI, and the third part, if there were any competition, what would be the reduction of prices to um, incorporate competition. And then at the request of some other countries, we developed another model that we call micro models because they evaluate specific markets. The first one, the aggregate one, applies to medication, and the second one to therapeutical treatments and alternatives. So the difference is we are able to see which groups can have replacement with therapeutic and economic um, alternatives. And so we developed it and applied it in different models. This is a snapshot to show you that it is something that has been developed in Excel in a very simple way, in a spreadsheet. We just incorporated the values of the variables, and that way you can forecast some of the results. The important part is to be able to have good data, reliable data to be able to feed the model. and the importance is how to obtain good information to incorporated into each one of the variables. And the measures that we normally evaluate in these studies have to do especially with patents and protection of test data. And in both cases, we ask ourselves, what is it that we're protecting through the quantity of products and the time of protection? In the case of patents, if the measures that we have mentioned in this panel promote and allow the obtainment of patents of use and patents and minor modifications to relax patentability models, or if we increase time of protection for some compensations due to delays, etc. And in the case of test data protection, what is it that we're protecting? What is it that we consider new chemical entity, or if we expand this concept, as Fabiana was mentioning, and how much would the protection time be? 5 years, 8, 10? Those who have been present in free trade agreements, they discuss this. And I also wanted to share with you the study by iPharma, or the Colombia has more history or the longest history in this type of studies, because when we've discussed with research groups in other country, patent is a term that becomes very common. In general, it's familiar to many of the social civil society members. However, data protection with, I know, frequently is not given the importance that should be given, and that is also generated by the society in the market, and it requires much less than the patent. So very frequently, the market of medication has many more medication with protection of this data compared to the patents, and at the end, it generates this exclusive nature in the market. The model is based on comparing two scenarios, a basic one telling us what our status is today, and several alternative ones which allow us to measure what would happen if another measure is implemented. And the results of the model are divided into three aspects: level of exclusiveness in the medications in the market, impact on prices, average prices in the market, and what's the impact on expense and consumption. This is a list of the studies we have conducted. As you can see here, you see many countries in Latin America: Bolivia, Guatemala, Argentina, Ecuador, Brazil very recently, and the dates on which they were conducted since 2004 until the most recent one in 2017. In 2017, we received the support from Shuttleworth Foundation, which charged us with four main duties: support the Mercosur study carried out by Fiocruz and ENSP by Brazil. Number two, allow public access to the documents available, so allow the public to have access. So we uh, made all the publications. We prepared a manual that would allow the researchers in the different countries estimate the impact. And of course, we shared all our impact studies. So we hoped that these documents are published in the iPharma web page very soon. We additionally agreed to verify what happened since the studies in 2004, where we made some projections. We needed to find out what happened with these forecasts. If after a few years, uh, all these forecasts were valid, what happened? And at the end, we needed to identify areas for improvement. This is a summary of what we identified in one of the Colombia studies. We took one from 2009 and we compared what we said in 2019 that would happen in 2018. We looked at the forecast we made with the available information, and we looked at what really happened in 2018. So what we see is that the market value has a difference of 7%. We calculated it was going to be 7% more. We were very close after 10 years with our forecast. And the impact protection on test data, we had anticipated that by 2018, 2018, there would be 33 new. And the reality was that in 2018, they were 85 molecules with protection of data, test data. So more than double what we had estimated. We also estimated a difference between the price of the medication that come into the market for the first time and subsequently the competitors. And that difference was estimated at 69% then. And so the competition would reduce the price in the market by 69%. And the difference in 2018 was between 60 and 78%, which is the percentage. So that means that the percentage we anticipated was correct. And finally, the price index constant. In 2009, we said by 2018, the increase would have been 1.115, and the real increase was 1.13. Of course, there were many other variables in intellectual property. We only analyzed these ones, but we need to complement it with others. So this is the evidence available compared to what we had anticipated, and the conclusion is that it was very close to our forecasts. This is one of the examples that we use to find the difference in prices, and it's got a particular aspect in it, and it is that frequently comparison of prices in medication, we see it at one point, like a snapshot. And at that same moment, we compare it with the price of the medication commercialized and the price of medication commercialized with a generic one. And this graph, what it shows, like many others, is the evolution in time when a medication is exclusive, which is shown in the green line, and then what happens with the price of the market when you start seeing competitors coming in. So that line in the center shows the weighted average price in the market mixing all the evidences in the market. And you can see differential price difference between 60 and 78%. After the third year, you allow competitors to come into the market. It's always in time. After the third or fourth year, one can expect a reduction of approximately 60%. Miguel, 2 minutes left. I'm about to finish. Thank you. And finally, I wanted to show you the study conducted in Brazil in 2017, which summarizes the results this way, going back a bit to the initial objective of the model that we showed in 2004. So it shows that for two specific groups of medications, medication for hepatitis C, it indicates four alternative scenarios, and it calculates with this methodology what the impact would be in each one of the cases. The first scenario is a scenario which tells us what would happen if we remove from our legislation a measure that would allow compensation due to delays in the granting at our Office of Patents. So they analyze what would happen if they remove a medication. If a measure already implemented, what would happen if we remove that measure, and we would save ourselves this money. The second one is what would happen if we include a compensation for the delays at the Office of Sanitary Registration, which delays the commercialization of the product, and that's the result. And third, what would happen if we put protection to the test data, and four, what would happen uh, by compensation to these test data. Each one will have the results, the corresponding results. At the end, it allows what we were saying at the beginning, the possibility for negotiators to have a tool to be able to discuss with their counterparties, especially the possibility to make transparent the possible impact for the entire society. Thank you very much. With this, I finish. Thank you, Miguel, for your presentation. I think you have given us a panorama of the development of the methodology and the studies that have been conducted and how these results have been able to become supporting information for negotiators, from the standpoint of the middle income to low income countries to be applied, especially in the region of the Americas. And to conclude, continue now with Joan Rovira's presentation. He will talk about the perspectives we have with the development of these studies. So, Joan, you have the floor.
Vale, bueno, yo voy a
Okay, so
utilizar algo
I am
menos
going
para también facilitar,
to
dar un
facilitate
tiempo para
and give some time
el debate y las
also for the
preguntas.
debate and
¿Se
the
me
questions
oye?
and answers. Can you hear me? Okay.
¿Hola? Vale, vale.
Yes, yes, yes.
Vale, vale. Bueno, entonces
Okay, so then
simplemente haré algunas
I will simply
precisiones o algunas ampliaciones a la presentación
make
que
some
ya he hecho de
compliments
forma
to
muy
the
clara y
clear
concisa, Miguel.
presentation
Una es de que, aunque
by Miguel.
inicialmente, ahí
One
por el
is that
2004,
although initially by
este modelo se
2004,
desarrolló
this
con la idea
model
de
was
ser una
developed
herramienta
with the idea to
para
become a tool
negociadores,
for
y casi decir, bueno,
negotiators
poder tener una herramienta
and be
rápida
able
en
to
el
have a
cuarto de
quick
atrás
tool
de la
at
sala
the
donde se hacían
backyard of the room
los
where
debates o la
all these
negociación y
debates
poder
and
hacer los
negotiations were
cálculos, bueno,
taking
si
place
acepto
and be able
eso
to make
o
the
si acepto lo otro,
calculations
cuánto me va a
as to
costar en los
whether
próximos
if I
10 años.
accept this
Esta era un
or
poco la
that,
idea,
how much would
pero
it cost
en
me? That's
realidad
the idea, right?
el
But
modelo puede
in
servir para
truth, this
evaluar
model could
cualquier
also serve to
cambio
evaluate
hipotético
any
de
hypothetical
políticas que
change
afecten
of
a la
policies
propiedad
that might
intelectual
affect
u otros
intellectual
factores
property
que
or some
influyan
other
en los
factors
precios, ¿no? Esta es
included in the prices.
la primera idea
So
que quería decir.
this, as far
La
as the first
segunda
idea
es
I
que
wanted to
el
share
modelo,
with
este
you.
tipo
The
de
second
modelos
one
de
is this
simulación o
type of
proyección no
simulation or
pretenden
projection models. I
adivinar
mean,
el
the
futuro, no
intention
son una
behind them
bola
is not
de
to
cristal para
guess
ver
the future. They're
exactamente qué
not a
pasará.
crystal
Sobre todo
ball to be
lo
able
que
to see
pretenden es
what
decir, bueno,
will exactly
suponiendo
happen.
que
But
va a pasar esto, que va
supposing
a
or
haber este
assuming that
número de
these or
nuevos,
this will
de nuevos
happen and that you
productos de
will have
mercado,
an
tantos de
X
estos
number of new
patentados,
products in
etcétera,
the market,
¿qué
patented,
diferencia
etc.
habrá
What
en
difference
impacto de
would
precios
you
y
see as far as
gasto
impact of
si
prices
tenemos esta
and
norma,
expenses if we have
o esta
these
cláusula de IP o
X
si tenemos una
standard or
nueva que nos
IP
están
norm, or if we have a
forzando
new
pues, los
one
países con
that
los cuales negociamos
the
o
countries
nos
with which
están
we are
pidiendo pues,
negotiating are
unas
imposing,
empresas
or
multinacionales
the
de forma
ones
directa.
imposed
O
or
sea,
requested by
yo diría que el
multinational
valor,
companies.
sobre
I would
todo,
say that the
de los
value, especially
resultados,
of the
es en
results,
términos relativos, no es que
is
el valor que
in relative
apuntamos, no
terms.
tal
It's
como se ha
not that
visto
the
en la
value,
presentación
as we have seen
que
in the
ha hecho
presentation
Miguel, pues
by
realmente en
Miguel,
un caso
in
han
one case,
aparecido pues
you've
muchas
seen,
más
for
patentes
example, many
de
more
las que había
patents
previsto. Porque, bueno,
than
el
those
modelo no pretendía
forecasted. So the
adivinar el
model
número de
did not
patentes, esto estaba un
intend to
poco
guess
fuera de
the
lo que
number of
queríamos. Por
patents.
lo
That was
tanto, ahora
outside
que
the scope
estamos
of what we
intentando
wanted. So
verificar pues, un
now
poco
we're trying to
la validez
verify
del modelo,
the
pues
validity of the
en realidad
model,
al hacer la
because
comparación
in
hay que
reality, when we make
utilizar
the comparison,
los
we
valores
need to
reales
use the real
de aquellos
values and
parámetros que
compare, I mean,
nosotros
those
estimamos
parameters that
en el
we
momento de
estimated
hacer
at the
el
time
modelo y sus
of
proyecciones.
preparing the model and its
Ah,
projections.
También quería mencionar
I also wanted to
que
mention that
realmente en este modelo,
in
al
this
principio había
model,
unas críticas por parte de
there were, I mean,
algunas,
this model
digamos,
generated
algunas
some criticism
organizaciones
on the
pro
part
acceso
of
que
some
decían que, bueno, es que
parties involved in
no
the
se
process.
podía
They would say or
entrar en
argue
este
that
tipo de dinámicas,
you
este
could
tipo de
not,
modelos, porque
use this type of
si
models
hacíamos pues
because
una especie
if we made some
de
kind
pruebas
of
de qué
a test
pasaría, ya
of
estábamos
what would happen,
aceptando que
we
íbamos
would be
a
accepting
realmente
then that
a reconocer, bueno,
we
estamos reconociendo que íbamos a
or we would be
aceptar
recognizing that we were going
los
to
active clues, ¿no?
accept
Y que por lo tanto pues
those
era casi tabú,
APIC
mejor
clues.
no
So it
hacerlo
was
eso, ¿no?
almost a
Bueno,
taboo,
nosotros
and then
creemos
they
que
said
no, que es mejor
they would rather
hacer
not
unas
do it. But we
estimaciones
believed that
razonables,
it was better to
transparentes
make
y que se
transparent
pueden
and
explicar
reasonable
y forzar
estimations
un
that
poco
could be
entonces
explored
a la otra
in order to
parte o
force a
forzar
bit
al
the
propio
other
gobierno del
party or the
país, al Ministerio
government
de
of the
Hacienda o quien
country
se vaya
or the
a
Ministry
intentar
of
convencer de
Finance,
que
whoever we want to
realmente se está
convince
pidiendo
that we
algo que
are
se tiene
really requesting
dimensionado,
something
¿no?
that has already been
Y
measured
finalmente,
and estimated. And finally,
creo que también es importante que
I think it is also
a veces se
important.
hacía la broma
I mean,
de que los
sometimes they
modelos
would make the joke that
económicos
the
y
economic models
epidemiológicos son
and
muy buenos
epidemiological models are very good
preveyendo el pasado, ¿no? En el sentido de decir que, bueno, que se acepta
read
que
the
el futuro
past,
no
but
lo
that
aciertan nunca, ¿no? Y esto es
they are
bastante
never
verdad, ¿no? Yo, como
able to
economista,
guess the
creo que
future.
hay muchos,
Well, I see that there are
sí, ¿no? Muchas proyecciones de
many
distintas
projections
instituciones
from different
sobre la
institutions
crisis, etcétera, y sobre otros factores,
in charge of
y vemos que,
crisis,
bueno, acierta
analyzing
alguien,
crisis, etc.
porque hay desde los
So
que
we see
dicen que
that
va a ir todo
someone
mal y
can
se va a
really,
reducir
make a
el
good
PIB en un
guess.
20% en los
Those who
próximos años,
say
hasta
everything
otros
is
que
going to
dicen
be
que irá
terrible.
un poco mejor
You see
y
the pessimistic
ganaremos
ones and
un
then the
5% de
optimistic
PIB.
ones where
Claro,
they
entonces, si
say,
hay
okay, we will be
un
able to
abanico
recover
muy amplio de
5%
valores,
of
alguien
the
lo va a
GDP.
acertar, más o
So if
menos,
there's
¿no?
a big fan
Pero lo
of
que sí que creemos que puede ser también
alternatives, someone will have
interesante
to accept
es
them. But what
para,
we
en
do
este
think
sentido es donde
could
se
be
hacía la
more
broma, es
interesting
para entender
is
el
is
pasado, ¿no?
to see it,
Y
to
hacer una,
understand
llamamos,
the past,
retroproyección, ¿no? Decir, bueno, si
making some kind of
hace 10
retro
años aceptamos
projection,
unas
saying,
ciertas
okay, 10 years
nuevas
ago
reglas
we
del juego,
accepted
porque
a new
se
game
aceptó el APIC, entonces
because ATPIC
podemos
was
intentar estimar con este
accepted,
modelo
so we can try to
qué hubiera
estimate with
pasado
this model
si no
what would have
hubiéramos
happened
aceptado
if we
estas
had
nuevas
not
reglas y nos hubiéramos
accepted
quedado
these
pues
new
con,
rules
bueno,
and
con las que
would have
teníamos
been
hace 10
left
años,
with the
¿no?
ones we had.
Yo quería simplemente
I
señalar
simply wanted to
que
indicate that
gracias a la Fundación
thanks
Shuttleworth y a
to the
Chapravala,
Shuttleworth
que es la
Foundation and
persona de
Chapravala, which is the
contacto que nos
person,
ha
the contact
apoyado en este
person who
tema,
has
pues nosotros estaremos
esses temas nós não tivéssemos podido encontrar
utilizar pues los modelos que tengamos,
todos esses
mejorarlos.
modelos que a gente tem para serem melhorados. Então a gente tem uma pesquisa aberta e utilizamos esse modelo simplesmente para fazer artigos e publicar, mas também para que
de un instrumento que alguien en un momento dado pueda tomar en un
that
momento
at
dado
some
cuando
point
tenga el problema
someone can
y la
use
posibilidad de
whenever
utilizarlo
they have the
y que
problem.
entonces
Well, they
tendrá
can
todo
use the
nuestro apoyo
possibility
para poderlo
or have the
aplicar
possibility to use it and
correctamente
be
o
able to
para
apply it
desarrollar unos
correctly
modelos
or to
mejores
develop
y más
better
ajustados
models, more
al
adjusted
contexto
to
en que se haya de aplicar.
the
Pues bueno, esto es
reality
todo y
or the
gracias
real
por habernos
context.
dado la
So that
oportunidad
was it.
de
Thank you very
hacer
much for
esta
giving us
cierta, yo
the
decía
opportunity
a Miguel que teníamos que hacer un
to
poco de
share with
marketing
you. I
en
was
nuestro
telling
modelo, aunque
Miguel
seamos
we
una
need to
entidad no sin fin
incorporate
de lucro, pero sí que es
marketing
bueno
in
que
the
se conozca
model.
que este
It is
modelo
good
está
for it
ahí.
to be
Solo
known
comentar
and
que ha habido
accepted,
en los
and just
últimos
want
años, ha
to
habido algunas
add that
demandas
over
de
the past few
utilizarlo, pero
years,
básicamente
there
han
have been
sido
some demands
pues
to use
personas
it,
que lo
but
querían para hacer
it's
tesis
people who wanted
o
to use
estudios
them
más bien
for their
académicos, ¿no? Pero
thesis
creemos
projects
nosotros
or
que,
academic
aunque esto es
studies. But
bueno
we
y
believe
no
that
vamos
although this
a
is
poner
good,
ninguna
we
limitación,
are not going
creemos
to
que lo
set
más
any
importante
limits,
es que
but
lo
we see that the
utilicen
most
los
important is to
posibles
be
usuarios,
used
los que
by
lo
the
vayan
possible
a utilizar como
users
negociadores, como políticos, como
who can
activistas que quieren
act
influir en
as
los políticos, es decir,
negotiators,
cualquiera de estos
activists,
grupos pues pueden
who can
encontrarle
exert an
una
influence in
utilidad a
politicians.
tener
Maybe these groups
unos
can also
datos y a tener
find
unas
them useful,
proyecciones
and
respecto a solo
well,
pues negociar
that way they will be
en
able
base a
to
la
make some
justicia, derechos
estimations and
humanos, etcétera, etcétera,
projections to
de una forma
negotiate more
cualitativa, ¿no?
towards social
Ya es
justice.
todo.
So I think, yeah, that's it. Thank you very much. Thank you, Joan, for your intervention and presentation.
En el marco de toda esta pandemia es que esto es conocimiento para enmarcado en ciencia abierta. Creo que en el marco del COVID lo que hemos visto es la competencia, el ocultamiento de la información y creo que esta es una excelente noticia y es una excelente iniciativa para algo que desde la sociedad civil pues todos hemos venido pidiendo para que el desarrollo de las cosas en el marco del COVID fuera más rápido y pues enhorabuena saludar ese tipo de iniciativas. Creo que es muy importante que eso lo tengamos disponible y pues agradecerte toda la disposición tanto tuya como de Miguel para promover el desarrollo de mejoras al modelo y de que se pueda utilizar en futuras negociaciones de los tratados de libre comercio. Bueno, ahora vamos a dar paso a las preguntas. Lorena tiene la mano levantada. ¿Podemos abrir el micrófono?
Hola, ¿sí se me escucha?
Sí, habla un poquito más fuerte, porfa.
A ver ahí.
Ya, mejor. Adelante.
Bueno, me presento.
Okay, I introduce myself. I am Lorena Dijano, Executive Director of Fundación HEP in Argentina. I wanted to thank all the panelists because it has been a very interesting panel in all the presentations, but I want to make reference specifically to the last two presentations, especially with regards to the Aprilia Method, which, thanks that it was developed here at the foundation, we were able to use it. Basically, what we've done is to do an impact study of the IP chapter that the EU had proposed in Mercosur in the negotiations for free trade agreement. And based on this method, which I want to say that it is important to have a methodology, a common methodology that has already been used previously. And as Miguel was showing, we've used it in different opportunities because this confirms that that methodology is valid. And it also defends us before the criticisms. But we want to say also that thanks to this study, and it was also combined with the study that Miguel presented done in Brazil. And finally, in the final text of this free trade agreement between the European Union and Mercosur, the anti-plus measures, all of these measures and the compensation patents is not there. So I want to also celebrate the existence of methodology and also celebrate that we have been able to have a political impact. And the negotiators were thankful because it's to reject these measures in the negotiation process is harmful for health. So, well, I want to stop there. Thank you very much. Thank you, Lorena, for your brief intervention. I don't know if any of the attendees, if you have any questions or any concerns or questions for the panelists. While you think of your questions, I have a question for all of you. During the presentation, we saw what was the development of the negotiations of the treaty and the challenges faced in the negotiation and the implementation, and what you need to do in the civil society so that the measures are not so regressive for the local population. With this panorama in view, what do you think are the alternatives that we have from civil society to advocate so that these measures that have been affecting us because they were adopted in the free trade agreement will lower the effects in these pandemic times? I would like to start with Roberto. What is your opinion, Roberto? What a hard question, Claudia. Well, I would like to say a couple of things that I consider important. I didn't mention them in my first presentation. The easy issue about intellectual property, I think that all those working on this during the negotiations, we had to illustrate ourselves in the practice. We really didn't know much about this issue, about IP. This is something that was esoteric for the work that we had been doing. So we didn't have the academic preparation for that. And also here in the country, in the academy, not even in the lawyers' offices, there was any kind of education in IP. An example is that in 2004, when we intended to buy alternative drugs for HIV or generic drugs, the lawyers group that was consulting the company that was going to do that, gave a report saying that we couldn't do that, or we couldn't have those drugs because they had a patent in the United States. Not even those very elementary basic knowledge we had at the time. So we have really learned in a hurry, and we have to consider that as a disadvantage because it has to do with the what reflections that you have to generate when you are in the dynamic of a negotiation. Secondly, and I go back to the academy again, our academy had nothing to do with this, not at all. And now I think that those that are prepared in the academy are starting to work with those companies, especially those companies that are interested in benefiting from the free trade agreements, especially in the IP chapter. But that we have a contestatory academy, with regards to this, we don't have it. So I was stating some disadvantages that we have, and that in reality do not create the appropriate context to think on what is the way for mitigation. Why? Because as Fabiana was saying in her presentation, the implementation process is a key process in order to avoid that with new words or prepositions, they increase protection to IP. So this matter here, for example, it is very difficult to submit an application to revoke a patent because it has a price. You have to pay for that, and a lot. You have to pay around $900 to just submit the application or the request or the claim. And only the negotiators have done that. Here, the Ministry of Foreign Trade and in the coffees that says that they defend the competition, but they don't really defend it, but they rather defend the international companies. Why? Because this door works very well in the copy and in the foreign trade ministry. It works really good. One time they are with transnationals, and then the next time they are within the copy and Exetur or etc. So what I mean here, I don't really want to become a victim here, but the matter is very complicated. Going into these negotiation processes when you really don't have an ally, you don't have any allies on your side. And I finish with this. For IP in the FTA Peru and the United States, and it also happened in the European Union and the TPP, the Ministry of Health was confronting the Ministry of Foreign Trade. They were confronted. They were both confronted. So who had the strongest political force? The Trade Ministry. So they were going against the Ministry of Health. And this is the data that we got from these studies mentioned by Miguel and Joan. Those studies allowed us to be there fighting to weaken the positions of these other institutions. Thank you very much. Fabiana. I agree with Roberto that it is a challenge, a very strong challenge. First, as a former negotiator, I know that negotiators are not experts in every topic. They don't have the time to get in depth in each technical topic. And that is one of the big differences that Roberto already mentioned with regards to the difference of power.
No, en español está bien, la traducción es simultánea.
Entonces, eso es uno de los temas.
So this is one of the topics, and that was one of the topics that we tried to work on a lot in all of the negotiations, being able to give the tools to the negotiators, the right ones. The beauty of this is that the only thing that we have to do is to provide information in on these technical topics. And once you provide the information, it's so evident and so strong, it's very difficult later on for the government not to see it. Of course, there are some cases like the case of Mexico, but many, when they see the weapons in the TPP negotiation, one of the negotiators says, yes, now,
Rapid access window. No, no, no.
look, the only thing I have to do here is rapid access. No, it is written there to make you believe one thing, but if you are looking at it in detail and carefully, that rapid access window was terrible, and it could cause 60 years delays in order to produce something. So I think that this is the main issue. If we continue educating ourselves, what we have seen afterwards, when we educate negotiators from one country, for example, Australia, those already have the knowledge and they can transfer their knowledge. And with Chile, the same thing happened with other negotiators. When we prepare the Chilean negotiators in the bilateral negotiation with the United States, there were many topics they didn't know about. And if we move on to the TPP, Chilean negotiators were in another position because they had already learned from the first negotiation. So the first thing was that education. I'm 100% in agreement with Roberto about the lawyers. It's not only with regards to the fact that if they were knowledgeable or not. In certain countries, there are some lawyers that are specialized in this matter, but the problem is that money manages the lawyers, and a representative from the medical industry in Malaysia said the problem that we have where we cannot contract any good lawyer's office because they're all committed for the industry. So I did have a case also where Pharma wanted to hire a lawyer's firm, but the problem was that you are representing generics, and you show the people, the money that can come if you don't represent the others. So that is something that is real. It's a real matter, a real issue. And they try to sort of like drown those that are working on this. Now, a couple of more things. One thing is you have to think out of the box. We have to stop negotiating based on what we have in front of us. Although we have achieved a lot of differences in this, or we still lack having a proactive strategy. We have improved the reactive strategy, but for many years we have said that we have to include clauses that are not there. They're absent. For example, the abuse of IP rights. In Australia, for example, they included something in their legislation, and although it's very small, it's very important. We have to think out of the box. And what is most fundamental of it all, and as Roberto said in his first presentation, is that we have to create a new model, a new financing model for research and development. And this is a bottleneck that we have. And this is designed to serve determined interests. And the reference made by Roberto to the WHO with the efforts made by the AMC so that we can have new alternatives, I do agree with him 100%. And most important topic that the industry is opposing to is okay. For the poor countries, this is one thing, but for these chronic diseases where they want to make money, they did allow that. And that's where we have to focus on create alternatives, financing alternatives for clinic or chronic diseases like diabetes, cancer, etc. We have about 5 minutes left, and I would like to give the floor to Nirmalyam.
Ahí estás.
Yeah. Right. I don't think there was any particular question put to me, was it? If I have not missed it.
Yes.
Okay. So, no, thank you very much for organizing this panel. I mean, I found it very, very informative, in fact, to know and understand the background of the negotiations in Colombia on the US FTA, that it has been a significant model, for example, in terms of the progress in terms of FTA negotiations. As we had heard, this was probably one of the rare occasions where it was not the United States, but the other counterparty, which was providing its own suggestions in view of a clear sort of definition of its interests, and also the domestic compulsions and the external sort of pressures that one had to encounter. This also shows perhaps the importance of having a more robust and systematic exchange of information among developing countries, because a lot of our countries are experiencing FTA negotiation trends from partners, namely the United States and EU. In Asia, for example, the RCEP has been a big sort of issue for the last few years, and India and it's been currently suspended, with India being not party to it. But there is also the possibility of FTAs being negotiated with the United States, and so one after the other keeps coming. So what would be perhaps important to sort of try to establish, and I know that civil society has been very, very active in doing that, but to take it to the next level, also at an intergovernmental level, and we, the South Center, also try to endeavor to do that, is to facilitate an exchange of the information about the experiences that negotiators from other developing countries have had. And the experience of Colombia, of Chile, etc. These would be very, very useful to share with parties outside the continent, in Asia, for example. And so that would be one of the suggestions that I would have in terms of FTA's environment in general. And of course, in the context of COVID-19, one needs to really think about how the FTA rules will come into play and how they can impact. As you perhaps will be aware, there is currently a proposal that has been moved in the TRIPS Council, which is going to meet later next week on the 15th and 16th, for a waiver of the IP obligations from certain sections of the TRIPS agreement, including patents, copyright, and also in relation to industrial designs, in view of the possible application of these IP rights to trade to COVID-related technologies. And this is a proposal that has been placed by South Africa and India in the TRIPS Council, but a similar sort of exercise could perhaps be looked at in the context of FTAs. Is there a possibility of suspending implementation of the IP obligations under free trade agreements in the context of public health challenges. Some of the FTAs have been raising have made references to the Doha Declaration, to the importance of public health. But perhaps now this is a unique situation, that an unprecedented situation that needs an unprecedented response. And perhaps there is an opportunity now to think out of the box and sort of try to see how do we address those issues, those challenges. So those would be some of my closing thoughts on this. Thank you.
Thanks, Nirmalia. Bueno, tenemos...
Now, we must finish. I'm sorry, Miguel and Joan couldn't give you any time, but we can continue with the discussion in the Telegram chat, where the group will meet again. For Joan, I think it's going to be very late. I think you're going to leave Miguel as a representative. So thank you very much to all the attendees and the panelists for having accepted the participation and for making this such rich discussion with different approaches. I want to thank the organization, all the people who were in the collaborative agenda.
Semana de Propiedad Intelectual, Interés Público y COVID-19. Esperamos que las discusiones hayan sido sumamente enriquecedoras para todos y esperemos que en el próximo año nos podamos ver presencialmente en Cartagena. Un abrazo para todos.
Muchísimas gracias.
Adiós. Adiós.
Hasta pronto.
Gusto de verlos, de verlas. Adiós.
Hasta luego.